Good evening, everybody. The audience today would include, I'm sure that a lot of presiding officers, a lot of senior advocates, and judges, and my dear beloved youngsters, to whom this webinar series is dedicated to. Myself and my co-host, Ms. Hemalatha, Advocate Chennai, are very happy for taking this webinar series to people across the state, now across the country. We have got participants in pan-Indian scenario, and we are very particular that the topics we are going to deliberate through renowned resource persons are of much importance, and it is going to help the participants to apply their practical life in the days to come. And today's topic is something very, 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 very unique. An act which has been almost forgotten for years together, and very few people, very few advocates know what is the act about. And I was not surprised when most of the participants asked in the WhatsApp whether any such act exists or not. Somebody asked what is called Inam, and people knew what is called a Zameen, but people never were acquainted with what is called Inam. So I said, please wait till Saturday, let Mr. Prabakar tell everything. He will cover from the scratch. And Mr. S. Pathasarthi, Senior Advocate at Chennai, was kind enough to request Mr. Prabakar to give an introduction about what is about and the subject matter from the introduction level. And regarding the resource person, an advocate, in my opinion, is very humble, very polite, at the same time, one of the erudite lawyer and my phono friend. Whenever I have any doubt on any subject, immediate phone call goes to three persons in my life: Mr. Raghavachari of Chennai, Ms. Chitra Sampath of Chennai, and Mr. Prabakar of Trichy. I have no hesitation in admitting that these three are my encyclopedia reference. That shows how much well-versed they are in their subject. And Mr. Prabakar has been known to me for a long time, and his prowess is something writing on the wall. He did his BSc Physics at Bishop Heber College, Trichy, and he did his BL at Government Law College, Trichy, and he holds two ML degrees, one in Constitutional and Administrative Law in the University of Nagpur, and second ML is in International Law in the same university, University of Nagpur, and his experience is more than 30 years. And more than my introduction, I'm sure that his deliberation will talk loud of him. With this short and sweet introduction, may I now request Mr. Prabakar to start the deliberation. Sir, you are welcome. The forum is yours.
I thank Mr. Srinivasan and his colleagues for their tremendous effort in coming out with this webinar series. And this is the 72nd. And when I was asked to pick out a topic, every topic under the sun have all been dealt with in one form or the other. Subsequently, I thought that one topic which nobody has touched is the Inam Abolition and its after effects. And somebody called me yesterday. I would like to even refer Mr. K. Subramanian, the Senior Counsel and Advocate General, former Advocate General, asking me one question: that the Inams have all been abolished, what is the necessity to have a discussion on the topic? With all my humility and command, I would like to present before you the scenario which makes us to revisit the entire issue. Why this topic with regard to the abolition at this juncture? There are three things which have come to my mind. One, instead of abolishing the which was the intention of the legislature, we have ended up today by abolishing the Inam Acts itself. and we are back to square one what we were before 1948. Two, somewhere down the lane, the courts found that the orders passed by the tribunal doesn't satisfy the requirement of this decision on title, and therefore left open the question. Two decisions come to my mind in 1986, Rajan Ramalinga Swami Madam's case has come there, and subsequently 1998. Therefore, these two decisions opened the floodgates, namely that whatever has been decided by the settlement officer and the tribunal thereof have all been consigned to dustbins. And even one of the judges remarked that it was only for fiscal purpose. Third, some of the judgment which comes out today from the High Court, with due respect and with all humility in my command, would say, painting a picture of large majority of the people in this state as land grabbers, trespassers, on the ground that these people are occupying the properties of the temple, and probably without even knowing the history how this problem erupted a couple of centuries ago and subsequently continue now today. Therefore, these are the things made up my mind that cases have to come to the court and will come. Second, during this pandemic, when lawyers are languishing with the absolute no work, there is a silver line in the air. It may be a gold mine in another 5 to 10 years, because very few lawyers may know the Inam Act and very few judges also. Therefore, with this introduction and the topic which I have chosen today came to my mind because of one reason, that many of the judgments which I have come across in the past 30, 40 years, a judgment which doesn't want to justify the reasoning, or any judgment which can be reasonable or justified may be sinful. Therefore, these judgments have cropped up, painting many of the people as land grabbers. Now coming to the history, how it has happened. Inam as such a word is an Arabic word. Even before that, we had Manyam. The Mohammedan rulers came with the idea of Inam. These Manyams are then called as Inam. In fact, one of the cases, even our Supreme Court dealt with, was a case of a grant made by Alauddin Khilji somewhere in 1170 or 1180. In these Inams granted by various rulers at many point of time, lost in antiquity. We don't have the grant, and then many things have happened in the 17th and 18th century, where the East India Company came into India and they took the help of some of the chieftains. We call them, many of them we can call Prince of Arcot, Prince of Karnataka, and they drove the Portuguese from the land, they drove the French from the land, and for which grants have been made to Prince of Arcot and even Prince of Karnataka. These grants, irrespective of the fact that it was a grant of the land as well as the revenue which had come later, have lost, been vanished. The reason is the court subsequently found these grants cannot stand scrutiny and these have to go. The peasants or the tillers of the soil must have a right over the property. But somewhere down the lane, the grants are also made for many other purposes, including religious purposes. And these grants alone now forms a large chunk of the properties in respect of, if I take a coup from his lordship in this judgment, more than 5 lakhs hectares of properties are available in Tamil Nadu. What happened was, before 1802, there were grants made fraudulently. You may ask how it has happened. It has all happened because of the East India Company came and they have a tie-up with the regional chieftains or zamindaris and started issuing grants to the rights. There were fraudulent grants made by them, and subsequently in 1802, the first regulation, permanent settlement regulation, came, and the first mistake was committed. The mistake was, under the regulation, it was stated that the proprietary right in the soil rests with the zamindars and landholders. That's the first problem which arose. In 1807, Thomas Munro wrote that these settlements made are fraudulent. Many of these sonnets are created by fraudsters, and therefore this 1802 regulation giving a proprietary right to the zamindar as well as the landowners started giving fresh sonnets as though they are the owners of the property. In 1822, there was a regulation again to clarify that what has been given under 1802 regulation is not an absolute or a proprietary right to the zamindar or the landowners, but it is only a limited right subject to the right of the tenants or the rats in possession of the property. In 1802 itself, there was a regulation. This regulation is 25 of 1802. Then there was a regulation 26 of 1802 wherein it was held that if the zamindars and the landowners have to register the property or to give us a grant or a transfer by sale or an assignment, then it has to be registered with the district collector. There was settlement regulation 1802, 26 of 1802. Nobody did that. What happened was these zamindars and landowners gave grants. We call it as Dharamila grants. These are the grants not approved by the then rulers. What happened was the zamindars, landowners indiscriminately at their choice gave many of the grants. This has went on from 1802. Notwithstanding the clarification in 1822, it went on till 1854. Then there was a hue and cry about this fraudulent sonnet issue. Yeah, hue and cry in a British Parliament, stating that many of the lands have been given by grants by the zamindars. They should not be recognized. The revenue from these lands have all been lost to the government. Then the British government took over from the East India Company. In 1858, an Inam Commission was established. This Inam Commission went into it and came out with the findings. And these findings were formed part of an Inam Fair Register, IFR, and the Inam Commission thereafter issued a title deed called as Inam Commission Title Deed. These two documents are very important when you go further into the discussion, because these are the documents which the Supreme Court as well as the High Court have said that authenticity cannot be doubted. It has to be given a great value. We will come there. But what happened was, once this commission, the Inam Commission title deeds were issued, the very same zamindars and the landowners thought that this title deed given by the Inam Commission gave a right which is larger than what they are entitled to. These things have happened and three legislation came. What are the three legislations which will want to this aspect can be found in the Madras Inam Act 1869, the Madras Inam Act 1862 and Madras Inam Act 1864. The point is, once this Inam Commission title deed was issued, the Act would say that what has been granted under the title deed is an absolute proof of what is stated therein with regard to title. Second, once this was issued and the Act has approved it in 1862, what happened was the zamindars and the landowners thought that this title deed issued by the Inam Commission gave them a right or a much better right than a right which they are entitled to, namely like a mail law. Subsequently, the Inam Commission title deed issued by the Inam Commissioner doesn't have the authority of the Governor General in Council, but it was issued by the Secretary of State. A clarification was given. And subsequently in 1866, it is said that Inam Commission title deed issued and by the Inam Commissioner and authorized by the Governor General will not limit, extinguish, or reduce the right or enlarge the right of anybody. It is only a recognition of an earlier right. After these two Inam Commission proceedings, the Melvaram grant, which is in many cases are issued under the Inam Commission title deed, many of the religious institutions found it impossible to collect the revenue. Therefore, another act came in 1871, Madras Pension Act. You call it as Madras Pension Act 1871. Under the act, the assessment or the revenue which has to be collected by the government, and then the Inamdas to whom this assessment is given has to go to the collector and collect the money. That is the Pension Act under Section 4 and Section 8 of the Act, and this Act was also past the jurisdiction of the Civil Court. And subsequently came the Estate Land Act 1908. Under the Estate Land Act, there is two provisions which are important. One is what is a private land and what is a royalty land. A private land is a land of the zamindars or the landowners who personally cultivate the land, and also the lands which they acquire from the rights and cultivate it continuously for a period of 12 years. Who is a right then? This definition, which should have been carried for another 100 years, has been lost because of judicial pronouncements. I tell you why. Under the Act, who is a riot? A riot is a person who cultivates a property by referring to the landholder or paying something to the landholder as a rent. One. Two, in case there is an exception or a proviso which says that in cases where a person is in possession of the property continuously for a period of 12 years and which cannot be referred, is referable to a landlord or a zameen or a landholder, then also he can be called as a riot. Why this act came? Because once the zameens and the landowners started claiming title on the basis of 1802 regulation, authenticated by the IFR or the Inam Commission, they think that they've got a better right, went to the court, tried to squeeze the persons or the tillers or peasants of the land. This riot definition was given only to protect riots who are in possession of the property. It may be referable to a landholder, or if it is not referable to a landholder, still, if he is able to show that he was in possession of the property for 12 years continuously and personally cultivating the same, he will be called as a riot. Why this riot definition assumes importance? The rights have been given a protection under the Estate Land Act. Estate Land Act is not applicable to every property. It applies to a property called as a property covered under the Permanent Regulation 1802 and a part or a portion of thereof, or in case of a palayam or a jagir. What is a palayam or a jagir? It is nothing but a land or an assignment given to a person for the purpose of defense, military purposes, for which the grant can be made, we call as Palayam or a Jagir. If I remember correctly, there is a judgment in AR 1955 Supreme Court, which says that in case of a Jagir, he is entitled to only revenue and not with regard to right to the land. 1955 Supreme Court. Then what happened was, from this act speaks about estate. Estate has been defined under the act saying that all pre-settlement lands vested with the zameen or a landholder can be called as a estate under the act. But this estate covers the Melvaram right. But in case of a Iruvaram grant or a Iruvaram right, I'll come there when the definition comes. Right, this right was not given under the Estate Act. In 1948, from 1908 to 1948, there was a lot of confusion because rights have been given possession, and subsequently we find that the zamindars making a claim in the sense that the rights are not rights, and they are not entitled to an occupancy right or a permanent tenancy, etc., or whatever call it. And subsequently, cases came up. And in one case, if I remember correctly, in V. Beriaman's case, full bench of the Madras High Court in the year 1953, I'll come there. In that judgment, it has been held that if a person wants to establish that the property is a private land under the 1908 Estate Land Act, he must establish that he is entitled to the property and he is in personal cultivation of the same. Namely, the burden is upon the zamindar or the landholder to show that it is a private land and not a rightful land. This definition was in full force from 1908 to 1948, no problem. Courts have held that once a party comes to the court and says that yes, it is my private land, then the burden is upon him. The burden is not upon the right. You just remember from 1908 when the Estate Land Act came, the burden is only upon the zamindar and the landlords, but not on the right. Because there is a presumption also, if somebody is in possession of the property continuously for a period of 12 years, he is deemed to be a right in possession of a right land. In 1948, people feel that the zamindari system is outlived. Once moving towards the independence, then the zamindari system has to be abolished. It was abolished under the 1948 Act, called as the Tamil Nadu, now the Madras Estate Abolition Act 1948. Under the Act also, it is stated that right in possession is entitled to protect his right. The abolition is only with regard to the right of a zamindar or a landholder, who is the lands which is defined under the Estate Land Act as an estate. What is an estate? An estate is a property which is covered under the permanent settlement of the year 1802, or any portion of it, or a grant given to a jagir or a polite. Please do remember that this estate cannot be a small piece of land. It is a larger tract of land. Therefore, once these types of estates come into force and people started making a claim, namely like zamindar, people started revolting, namely that the hundreds of years that tillers are in possession of the property. One fine morning, somebody comes and says that no, I am the owner of the property under 1802 regulation, I am entitled to it, vacate. Then to put an end to these things, the abolition came. absolutely no issue. The abolition went to smooth in so far as the estate is concerned, because there was no mercy for the zamindars and the landholders. Because large tract of land, you can't imagine people controlling it, but there are tillers in possession of the same for hundreds of years. The legislature then found that merely abolishing the estate is not enough. There are vast lands available which comes within the purview of an Inam grant. It may be an Inam estate or maybe a minor Inam. What is an Inam estate? An Inam estate is a whole village. If the entire village is granted as an Inam, we call it as a estate, Inam estate. If a portion of the village is given as a grant, then it is called as a minor Inam. There is no major Inam, we call it as an estate. And in case of a minor Inam, a small portion of a village is granted, then it becomes a minor Inam. The legislature thought it fit that these things have to be abolished. Then a patta has to be granted, a right-to settlement has to be made. Why this right-to settlement has to be made? The problem is, the grants have been made by this sovereign and not by individual. I like to bring to the notice of my friends that there is a difference between an Inam and a specific endowment under Section 6 of the Insurance Act. Section 6 speaks about a property given by an individual for a particular purpose, a religious purpose covered under Section 6 of the Insurance Act, called as a specific endowment. We are not concerned with that. But the Inams as such are not granted by the individuals, cannot be granted by individuals. No Inam granted by an individual is recognized as an Inam. Inam granted by the sovereign alone is recognized as an Inam. Inam comprises of two things. One is the land revenue and another is the land itself. What is a land revenue? It is the assessment. If you go into the Abolition Act, you say there is a definition of land revenue. It is nothing but a revenue assessment. The revenue assessment can be given, or the revenue assessment plus a right in the property can be given. If a revenue assessment alone has been given, it is called as a mail. If the revenue assessment along with the right in the soil is given or under the grant, it is called as a Kudivaram. The point at issue is whether the sovereign has got the right over the lands to grant both the assessment as well as the right in the soil. There is no doubt that the sovereign has got a right to impose assessment. Therefore, it has got a right to give a grant in respect of a land revenue. But insofar as the grant of the Kudivaram right, or what we call as a right in the soil, unless the sovereign is the owner of the property, or unless the sovereign is in possession of the property, then alone it can give you a grant. Do bear in mind that a sovereign can also lose its rights due to lapse of time and prescription. But we don't encourage all these things now because the political tide sinks with the judicial tide. The point for consideration is whether the sovereign has got any right over the soil. Assuming for a moment 500 acres of land, 600 acres of land is given by the sovereign, can we assume that the sovereign is entitled to the entire property, every inch of the property to grant the income? When we go into the interpretation, we have to keep in mind that these are the norms granted by the sovereign and not by an individual to the religious institutions. Now coming to This factor, namely a male waram is only a revenue assessment or a land revenue. Kudi waram is a right in the produce or a right in the soil. How this waramdar is defined? Waramdar would say that they have to share the produce between the riot and the landholder. And if this is done, then there is absolutely property or the grant given by the sovereign can be called as a iruvaram grant, namely the male waram as well as the kudi waram. But the problem is, the sovereign cannot make a grant of kudi waram alone. It can give a grant of a male waram alone. It can give a grant of both the warams. But it cannot give you a grant of a kudi waram because the assessment, normally the assessment has to go with the grant. Therefore, male waram can be granted by the sovereign or both the warams can be granted by the sovereign. It cannot be a grant of the kudi waram. How about this Abolition Act? 1963. These two acts came. One is the, am I audible?
Yes, sir, you are audible.
One is the Inam Abolition and Inam Estate Abolition, and another is the minor Inam Abolition. What happened was, these two acts intended to abolish the language used in the act itself is to abolish the intermediaries. Who are the intermediaries? The intermediaries between the sovereign and the people who are in possession of the property, namely the zamindars, the landholders, whom the grant is made. Why this has been abolished? One, you should make all the lands freehold lands. If the country has to move ahead, you can't have a tie-up of these properties forever. Even when 1802 regulation came, the British thought that instead of giving a grant in respect of the land, it is better to give a grant by way of money compensation. That's why the Madras Pension Act 1971 came. The point is therefore, once the legislature wants to abolish these, the intention is to protect the person who are in possession of the property. But what is the difference between the Estate Land Act, Estate Abolition Act, and on the one hand, and the Estate Abolition and the minor abolition? It is only a judicial fiction. Namely, under the Estate Land Act, a right need not show that he is a right in possession. On the other hand, the person who claims right as a private land must show that it is his private land, two, he is in possession of the property, personally cultivating it. And there is also a presumption with the word a person who is in possession of the property is for a continuous period of 12 years is a right under that act. But once this act came, namely 63 abolition acts, the courts have forgotten this principle. And they have held that once this abolition is made, a person who is in possession of the property, mere possession is not enough. Now I'll come to the abolition, how it has happened. The Act recognizes both the acts, both the Inam Estate as well as the minor Inam, recognizes a grant of patta to the kudi waramdar, or a grant of patta in respect of a iruvaram held by a religious institution, and the exceptional cases, namely the lessee cultivating grant, etc. This kudi waram right became a problem. How it became a problem? These two acts speaks about not only the abolition, vesting of the property in the government from the appointed day. In respect of estate abolition, it is from the 1st July 1960. In respect of a minor Inam abolition, it is from 1/4/1960. That is the appointed day in these two acts. These two acts speaks about the vesting of the property in the government. If you take the section 3 of the act, both the acts, it would say that all the lands, whether it is estate or otherwise, I will give an example by taking the Minor Inam Abolition Act, section 3. Vesting of minor Inam, 3B, just take 3B. I'll read that also. Every minor Inam, including all communal lands and purposes, wastelands, pasture lands, forest, mines and minerals, quarries, rivers and streams, tanks and mooraries, including private tanks and irrigation fisheries situated within the boundaries thereof. Now note the language. Shall stand transferred to the government and vest in them free of all encumbrances, except and the Madras City Revenue 1851, except section 2 and 12 of the Madras City Revenue, except the Revenue Recovery Act. The point for consideration is, shall stand transferred to the government and vest in them. What is the language? And what is the import of this section 3P? Whether after the abolition, the entire property will vest with the government, and then one has to go under the act to get a right. If you see the next 3C, it would say that all the rights created by the Inamdar, inner over the Inam before the appointed day, shall, as against the government, cease to determine. Inamdar who has created right, it may even be a lease, it may be a mortgage. All these things will cease from the day. Next, what are the rights given to the Inamdar? The Inamdar is only entitled to the right what has been conferred under this act. And what is the right of a person in occupation? He is also entitled to a right under the act. Therefore, the sum and substance of the act is abolish the intermediaries. The government, all the properties and all the rights created by the Inamdar shall stand best with the government. And then under the act, the settlement Tahsildar has been appointed to go into the right of the person to whether a patta can be granted under what circumstances, etc. But the point at issue is, this has not went well down with the courts. The courts found that there cannot be a statutory transfer of the properties. That opened the Pandora's box. The act was well intended, namely, you abolish all the intermediaries, start with a clean state, and give right to some people who are entitled to under the act, let them get the patta, make them freehold, and the intention is to abolish all the intermediaries so that the lands can be converted into right or patta. Has it happened? Certainly not. The point was, once this act came, the mind of the legislature is very clear. The abolition is in respect of the Inams, but that was the intention. But the jurists were trying to save the Inams. On one pretext or the other, judgments came by which these have been reduced into a fiscal act, not in respect of a right given to them under the act. The patta has been shown to be a mere patta for fiscal purpose, although it is a revenue patta, etc. There are very many judgments on that aspect. Therefore, once this act comes into force, the rights have been to be defined and who is entitled to the property. One of them is Kudivaram right. If a person has got a Kudivaram right under the act, he is entitled to a patta. But quite unfortunate that Kudivaram right was also not properly recognized by the court. What it said, that under the act, a person has to prove that he is a Kudivaramda either by a grant or by way of a documentary evidence. We feel that this interpretation is not warranted by the act. Now, if you take the act which says that a person is entitled to a rightory patta if he is lawfully entitled to Kudivaram right. That is the language used. What is the meaning of the word lawfully entitled to Kudivaram? Does it mean that a person has to produce a grant? Now equating this to the Estate Act. Under the Estate Act, a right in possession for a continuous period of 12 years is deemed to be a right. Whether or not it is referable to a landholder. There are two definitions given. One is a person, a right in possession referable to a landholder, a right in possession continuously for a period of 12 years. And he is not able to show that he is in possession referable to a landholder also. If his possession is for 12 years continuously, then he becomes a right in possession of a rightly land entitled to an occupancy right. Why the court have not extended this to the Kudivaramdar? If the Kudivaramdar is able to show that he was in possession of the property for 12 years prior to the advent of the act, then he should have been granted a patta. It has not been done. The judgments came exactly the opposite of what we were under the Estate Land Act. It says the Kudivaramdar is not a cultivating tenant. A mere cultivating tenant cannot become a Kudivaramdar. And therefore, if a person wants to say that he has got a Kudivaram right, he must establish by way of a grant or a document, putting the onus on the other side. The pendulum started swinging from one side to the other. Then, very few people could get a patta under this section. So, even though they are in possession of the land for a long period of time, they didn't get patta. If they are not entitled to patta, then the landholder becomes the owner. And how these cases are coming up to the court now. If this Kudivaram right has been properly clarified, then many of the questions which have been raised by the courts now and amply reflected in the social media day in day out, painting everybody as an author and the property grantor would not be there. The second is in respect of, there is a grant of patta in respect of a Kudivaram right. The next is grant of patta in respect of Iruvaram. Iruvaram grant under the Act speaks about a religious grant, for which whether a patta can be granted to the tillers or person in cultivation of the property. Here again, the decisions made by the courts were not in consonance with the Act. How it has happened. Under Section 8 of the Minor Inam Abolition Act, equivalent is also there in the Inam Estate Abolition Act. Even in case of an Iruvaram grant, a person has got the property or the land has been transferred by way of a sale. If anybody has got the Act, kindly look 821 of the Minor Inam Abolition Act, 1963. I'll read that bit. I'll skip to notwithstanding anything contained in subsection 1 in Tamil Nadu HRMC and unincorporated Devastan 1959, the following provisions shall apply in the case of lands in an Iruvaram minor Inam granted for the support or maintenance of the religious institution, or for the performance of charity or service connected therewith or any other religious charity. This will take into account all the grants. I will come there when we discuss about the various accounts. The 2.1 and 2.1 in and B are important. What one says, where the land has been transferred by way of sale, and the transferee or his heir assignee, legal representative or person deriving rights through him had been in exclusive possession of such land. What it says, a person should be in possession in pursuance of a sale, one. And there are two provisos or a provision which says if he is in possession for a period of 60 years, before the 1st April 1960, he has to pay some amount. And if he is only for a continuous period of 12 years before 1st April 1960, he has to pay some amount, probably it is lesser than what it was, larger than what it was, and he can get a right to right fund. What this section shows, if there was an Iruvaram grant, namely a grant given by the sovereign of both the Varams, male Varam as well as the Kudivaram, right? And in respect of those lands, a person has purchased the property and he is in continuous possession of the property for a period of 60 years, one, or is it assignees or representative, or a person in possession of the property for 12 years continuously. Many of the cases would have gone out and the patta should have been granted to the people who are in possession of the property in pursuance of a sale. That was the intention of the legislature. But what the jurists thought, this sale should have been made not by a person who has no right, but by a person who is the manager of the religious institution, or a person who has got a grant in his name. Forgetting for a moment, before 30th September 1951, if any person in possession of the property for 12 years continuously, in case of a property of a religious institution, he would have prescribed title to the property. And under the old Limitation Act 1908, if the religious institution did not file the suit within 12 years, it will lose its rights, not a case of an adverse possession. That's why, under the HRMC Act, itself a date was fixed, namely 30th September 1951. What this Act says is this: it gives another period of 9 years, namely up to 60. The Act came in 1963, probably the bill was placed before the legislature somewhere in 60, therefore this 60 was given as the date. If a person is in possession of the property for 12 years, before this Act, under a sale deed, then he should be entitled to a property. But the point is, what is the difference between an adverse possession and this section? In under adverse possession, you have to prove your animus. But under this section, there is no need for an animus at all. If a person is able to show that he has purchased the property and is in possession for 12 years continuously or for a period of 60 years, then he is entitled to patta provided he pays the nominal amount. The point at issue is this transfer by way of a sale, as found in section 821, was restricted by judicial fear as a sale made by the religious institution. I am afraid all those judgments, including the Supreme Court, are erroneous. The reason is this. I can also draw an analogy from the latest decision of His Lordship Arun Mishra under section 6 of the Hindu Succession Act, wherein His Lordship had said that the daughter of a co-partner under section 6 doesn't mean daughter of a living co-partner. The court has no power to introduce a word which is not found in the statute. That is exactly the word used by Trichy and the later judgment. And any word which has been used by the legislature, by the judiciary in the section 2(1), that a transfer by way of a sale made by the religious institution. That is it. Who has introduced it? Who want to save or to create chaos? The point is, yeah, by judicial fiat, it has happened. How it has happened? In one case, if I remember 74 law weekly, there was a case where a service is now alienated by a person or a service dog. And after the act, under the proceedings under the act, the patta was granted to the person who has purchased the property under the sale. This was appealed. And then some other case came to the Supreme Court. If I remember, ATS Chennai, 1996, I think there is a judgment. I'll refer later. In the judgment, when the earlier judgment of the law weekly was cited by, unfortunately, the court said that that was a case where a servicedar has transferred the property. In this case, there is no servicedar. It is a stranger. Therefore, the Honorable Apex Court introduced a word that a transfer by way of a sale by a Inam, which doesn't find a place in the statute. If it doesn't find a place in the statute and a decision in Chennai is, in my opinion, erroneous, and in the light of his Lordship judgment, the latest judgment, that the court has no power to introduce a word which does not find a place in the statute. That's how the problem has cropped up. Many of the people who are in possession of the property in persons of the sale were not in a position to get the patta. The object of the act is to abolish the intermediaries. What is this object? Once you abolish this Iruvaram ground, what is the consequence? It's not that the religious institution has been left high and dry. And nobody has touched, except two decisions which took into account the Tasdik allowance, which is contemplated under Section 19 and 20 of the Act. One is in 1971, if I remember, the Supreme Court decision, wherein the Lordship has held that a compensation as found in Section 19 and 20 is more beneficial to the institution rather than any individual. And then of his Lordship E. Padmanabhan in 2003 would have. But the courts found that under Section 3(2), abolishing or extinguishing the right of the religious institution is not good enough or not sane enough, may be sinful. Therefore, it introduced a word which does not find a place in the statute and deprived many of the persons who are in possession of the property. Now, stopping here for a moment, we will go into the history, how this country has valued the right of the person who is the first occupant. One can find that the first occupant normally entitled to the property. Who is the first occupant? Certainly cannot be a Jamindar unless it is his private land. Certainly cannot be a landowner unless he is in possession of the property. In one of the oldest judgments of his Lordship C.J. Turner, Chief Justice Turner, along with his Lordship Mutsami Iyer, reported in ILR 9 Madras 175. There was a case of Secretary of State with Veera Raja. The first time, in fact, because we don't have any judgments before that, is the lordships have held that under the Indian customary law, a person in possession of the property is the first occupant and entitled to the property. This judgment was subsequently followed in ILR 26 Madras, page 252. The point at issue is whether any zamindar or a landowner would have been in possession of the property, this vast tract of land. Why the East India Company would have granted a sanad or by way of a regulation allowing the zamindar to have a proprietary right and they in possession of the property. It is not even the British government. Before 1856, it was all the East India Company. The point, therefore, is the first occupant has got a very valuable right under the Indian context. That has now been thrown to winds by some of the judgments which say that possessory right is in violation of human rights. If I refer his Lordship, Dalivir Bandari judgment reported in AR 2009, he also made a cry in the next judgment that reduced the period from, increased the period from 12 years to 30 years. And thank God, another judge came, his Lordship Arvind Mishra settled the issue with regard to the possessory right in this country. The point, therefore, if a person has got a right by way of possession, that is an invaluable right under the Indian context that cannot be disturbed. Then, what is a Melvaram right? Melvaram right, it went through, if you find the judgments from the 19th century, or the fag end of the 19th century, and the first part of the 20th century, and subsequently after the independence. There is a vast difference. I tell you why. In India, southern India specifically, the right given by the sovereign can only by way of an assignment of the revenue, more so in case of a religious institution. I can draw inspiration from the very famous book on the store, Land Tenures by Saudara Jayega. I think the last edition came in 1921. We don't have a book also. But in that book, we find that a person who is in possession of the property is entitled to the property, and secondly, this Melvaram can alone be granted by the sovereign, more so in case of a large tract of land is granted or the assessment is made. And this has also been echoed. I think Parthipan can show the judgment. Secretary of State versus Srinivasacharya, AR 1921, Privy Council, page 1. There is a definite wording in that judgment which says that a grant made by the sovereign can only be of a land revenue. This is also echoed by the subsequent judgment. The AR 1937 Privy Council, page 209. Before 1947, or even with the word abolition 48, in this country, we were of the view that a sovereign has got only a right to grant assignment or right to grant revenue alone and not the property. There was also a presumption. If you go through the judgments till 1949, people were under the impression that many of the judgments reported in IL law before 1900 say that there is a presumption that a sovereign grant made by the sovereign can only be of a land revenue. But this has been put an end to by the decision of the Privy Council in the year of 1949, or you call it 1949 2 MLJ page 500, Lakshmana versus Venkateswara. In that case, his Lordship Sir Madhav Nair, after making an elaborate analysis of the judgments, found that there is no presumption either way. If anybody comes to the court, then it is for him to prove whether the grant is a Iruvaram grant or a Melvaram grant. Therefore, the earlier view, which was stood the test of times, have been put an end to, and there was no presumption at all. In each and every case, one has to prove the burden is on the general law, burden is upon the plaintiff to prove whether it is a Eru or a grant. This is 1949 judgment. And what is a Kudivaram right and how this has been taken into account? Before going into that, I would like to refer the full bench decision in Periyannan versus Arabadeswara Soundaranayaki Temple, AR 1952, Madras, page 323. A classic judgment. On some other point, it was overruled by the Supreme Court, unnecessarily, in my view. A classic judgment where three judges wrote three independent judgments. One is of His Lordship Satyanarayana Rao, and another is Krishna Rao, Justice Krishna Rao, and another is Vishnu Shastri. These judgments should show it is all under the Estate Land Act. The character of the land, how this has to be proved in a court of law. Then the court has given up with 7 points. There is no presumption with regard to either Melvaram or Kudivaram. But the court has said one thing, that under the Estate Land Act, it is the burden is upon the person who claims the land as his private land. And how he has to do it, he should show that it is not only his land, but he is in personal cultivation of such a property for a continuous period of 20 years. This is a landmark judgment we call as a re-Periannan's case in those days. And this has also been subsequently, this Kudivaram right was taken into account in some of the judgment at the time of interpretation of the IFR and the Inam Commission title deed. Now I will come to this IFR. Before that, we will deal with the glossary of the terms which will be necessary to understand the IFR as well as the Inam Commission title deed. To my mind, there are 4 Inams. In fact, in Land Tenure Soundararajan's book, it has been given as 9 Inams. But when you find in the IFR, there are only 4 we can find. One is Devadayam grant, Dharmadayam grant, service, and personal. What is the Devadayam grant? Many of them think Deva means God. It's not so. Devadayam grant is a grant for the religious purpose. It doesn't mean that it is a grant to the Almighty. That is the settled definition. But we have to see the other column will come there and we interrupt IFR. Devadayam is only a grant for a religious purpose and need not be for the Almighty. Dharmadayam is a dharma, charity, service. A service grant is a grant in favor of the Inamdar for doing a particular service. It's more like an emolument for doing a particular service. The grant will be in such cases in favor of the Inamdar. If the service is to the Almighty, it will be the name of the idol. If the service is a public service like a village headman or a karnam, then it should be the name of the personal service. This is a grant in favor of the individual for doing his particular service. The grey area is many of the courts find that the service grant and personal grants are one and the same. It is not so. In case of a service Inam, the grant is in favor of the Inamdar. And this grant is given for a person to do some service, and this is property is given by way of an emolument. Personal grant is a grant in favor of an individual and who has to do some service. The reason is difference is this. In case of a personal grant, a person is entitled to transfer or alienate the property. Personal grant is an alienable and a transferable grant. But service grant is not so. But the service grant as such, you can find a place in the IFR in the first column or the secondary column about the service. I will come there later. The words which are frequently used in old age, one is sarvamanyam, tiruvimanyam. If it is the assignment of the land itself, the deed might use the word sarvamanyam. If it is an assignment of the revenue alone, it may show that it is a tiruvimanyam. Tiruvai is assessment. Tiruvimanyam. And coming to other glossary terms, what is dustic allowance? We frequently use dustic, mohini, various deduction, and quit rent. Under the Act, they use the word dustic. It is a compensation, and a compensation, annual compensation to be paid so long as the inamdar exists. Even under the Abolition Act, the compensation contemplated under Section 20 has to be paid so long as the service exists. That's called as a dustic allowance. It may be, it's a money compensation. Rather than giving a land, give them money. Make the land freehold so that it can be used for some other purpose for the country. The country needs freehold property, which unfortunately the courts are not equipped to do. Mohini. What is a mohini? It is also an allowance which was widely used before the Abolition Act. Before the Abolition Act, the annual payment made by the sovereign to the religious institutions or to the inamdar is called as a mohini. Only under the Act the dustic word came. Then what is bailiff's deduction? It's quite interesting also. It is an indirect payment to the inamdar, whereas the dustic and mohini allowance are a direct payment by way of money to the institution. Bailiff's deduction is a deduction to be made from the overall revenue collection from a particular village. And this will be given indirectly to the institution. Suppose the institution exists in a particular village, and this deduction would show that the institution need not pay any money to the government by way of assessment. That will be deducted. This is called as bailiff's deduction. In IFR, before the Abolition Act, if the property is acquired by the government for some other purpose under the Land Acquisition Act, you can find this entry being made or recorded in the IFR itself that some bailiff's deduction was made or the mohini allowance was paid in lieu of the acquisition paid. But one should bear in mind, this dustic, mohini or a bailiff's deduction all points to one direction, that it is in respect of the land revenue and not the assignment of the land. If it is the assignment of the land, then there is no need to have any allowance at all. Because you give the property itself. If the property is not given, but what has been given is by way of money compensation, then it is called as various names as dustic, mohini, bailiffs. Then what is quit rent? Now we use the quit rent in some other context. Under the old law also, this has a prominent place. This quit rent is paid by a person who is an occupation to a person who is owning the land. Quit rent, if is paid, you recognize as the right of the landowner and you pay money to the landowner. You call it as a, if a person is a Kudivaramda, he pays money, or if he doesn't have any production or cultivation of the land, he has to pay quit rent, namely the rent which he is liable to pay to the higher owner, namely the landholder, and this is called as a quit rent. Then what is the word used in jargon? I said at the opening that under the Estate Land Act, the estates is defined as a settlement under the settlement regulation, and then the grant made to the polyams and the joggers. This is nothing but a grant of revenue alone. Because joggers are for the purpose of defense or military, it is only a revenue and it has nothing to do with the land. Now, coming to the types. If a religious institution holds the property, as I have said, that it is a Devadayam grant or it may be a service grant. For which this Devadayam or a service grant, there are three, we can classify under three heads. One is retention of the land subject to certain service. This has happened at even at the time of the Inam Commission, enfranchisement was made, and at that point of time, a right was given to the servicegar to make the land freehold by paying money. Three options are given for them at the time of Inam Commission inquiry. One is to retain the land, do the service. That is the first option. And probably these are the cases which are nagging the courts now. Doing the service, subject to the condition of doing the service, retaining the land, and somebody is alienating, it is all revolting to the court. Two, consenting a payment of annual quit rent, and to relieve themselves of the liability of service. Don't do the service. You pay some money annually. Every year you pay. Get the property as a freehold, but you are bound to pay this quit rent annually, but you can enjoy the property. The third option, consenting for a one-time payment and make the property freehold. The first is you continue the service and there will be an entry. Two, if you want to convert it, free the property from the liability, pay annual quit rent and keep the property for yourself. The third is pay the money and get out, make the property freehold. These three types were given as an option at the time of Inam Commission inquiry. Many of them probably would not have taken that. Even under the abolition, they have failed to do. Now coming to the IFR, Inam Fair Register and Inam Commission title deed. As I said earlier under the opening of my statement, when Taylor was appointed as an Inam Commissioner, he went into all these things in 1858, completed the proceedings somewhere in 1860 to 63. After all the inquiries, is registered by call as a Inam Fair Register. And after this Inam Fair Register was all over, the conclusion has been converted into a title deed. We call it as a Inam Commission title deed. This Inam Fair Register, when the preparation was made, some rules have been laid by them, by Taylor as well as the subsequent man who are called as Travelling, Mr. Travelling. There are 22 columns. What they found was, they have to appoint somebody to verify, because of why it has happened. There was a hue and cry in the British Parliament in 1854 that fraudulent sannads are issued, pre-settlement, post-settlement sannads, etc. And therefore, they want to go into the question of settle the issue. Quite unfortunately, after 150 years, it has not yet settled. This Inam Fair Register consists of 22 columns. The first column is you may find number of holdings or a single holding. That means, if the Inam is covered under a particular single title deed, or in very many title deeds, 1, 2, 3, 4, etc., are the number. We don't find that number there. It will say only the sequence numbers, whether the Inam Fair Register comprises of a single holding or a number of holdings. Column number 2 to 7 are very relevant. It speaks about extent, class, and value of the property. Why I am insisting on this? An interpretation of the document has to be made to find out what was the nature of the grant, whether it was a Devadayam, Darvadayam, service, or personal. Second, whether it is a Melvaram or both the varams, for which all the 22 columns have got some significance. 2 to 7 speaks about extent, class, and value. What is this extent and class? Extent has been given with regard to the area of the property. One is at the normal Indian standard and another is the English standard. And then class and value. What is this class? Wet, dry, garden. These three types of classes we find in the document. Wet, dry, or garden. Value. Value has got a great significance. It speaks about the assessment value. The property which is liable for assessment for some value, this value can be found placed in the column. These are the column number 2 to 7. It will be one. If you see the Inam Fair Register, can Mr. Parthiban show that a copy of the IFR is available?
Just a minute. Parthiban, please show IFR. Share IFR.
The column number 1 is only the serial number, or we will say the number of holding. Column number 2 to 7 will be clubbed together. And this column number 2 to 7, the first column will speak about the nature, namely whether it is a Devadayam, Darvadayam, or personal. Please do note that this column will not speak about service account. You have to interpret the document from some other column. I will come there. So column number 2 will speak about only 3 Inams, namely Devadayam, Darvadayam, or personal. The reason is service is also so intricately associated with the Devadayam. We don't find service as in the column. These 3 columns will be there. The pointer is, if it is a Devadayam, then you can say that it is for a religious purpose. Whether it is to a almighty or an idol, we will find from the other columns. Similarly, if it is a Dharmadayam, we can say that it is a charitable purpose. What is the charitable purpose? Then we have to see whether it has been given to a Mohammedan, like a Kairatina. We call it in Salem district, it's called as Kairatina. That is for a Dharmadayam. Personal, as I have said earlier, it is a grant will be in favor of a particular person. Then the other 2 columns will say that the dry, wet, garden, and then assessment will be there. Then column number 8 to 12. If you find on the next column 8 to 12, it speaks about the description and tenure of the documents. What is the tenure of the documents? It may say that it is permanent, or it may say hereditary. We will come there. If it is a service, it can be a hereditary. If it is a grant to the Devadayam, then it will say that it is permanent, so long as the Inamdar exists. That is called as a description. There is a nature. Who was granted is column number 30. Nature of original grantee. Who has granted this grant? In most cases, My personal experience, I found that this column in many of the cases in IFR is vacant. The reason is this. If the Inam Commissioner was not in a position to find out who has given this grant, then he has to leave the space vacant. And many other cases it will be vacant. 14 to 20. What is the nature and extent of the property as per the regulation in 1802? That's how this 1802 regulation comes into picture. Because from 1802 to 1865 or 64, when this IFR was prepared and published, there's nothing in between except one or two regulations, not with regard to this right of the zamindars or the landowners. Therefore, it will say 14 to 20 will speak about who is an occupation of the property or original occupant, who is the present holder of the Inam. Many cases you find that the present holder, somebody will be occupying. If he is in possession, it will be shown. Then column number 21, we call it as a remarks made by the deputy collector. And column number 22 is the decision made by the Inam Commissioner. I will come to the last two columns thereafter. The first is interpretation. If you say the IFR has to be read as a whole, to find out what is the nature. Nature is two types. One is whether the sovereign gave a grant of the land revenue or the both the volumes. That you have to find out from the IFR and the title deed. Second, what is the nature? Whether it is a Dharmadayam, Devadayam, or it is a Vasala. From the second column, you will be able to find out the nature or the character of the Inam. But the interpretation which the courts have made over the years and subsequently for the past 50 years forgotten by the courts itself is the very valuable columns, namely column number 3 to 7. Column number 3 to 7 speaks about dry, wet, garden, and then assessment. This is a grant. If a grant is given, why these things have to be mentioned? That is the first question. To interpret a document, if there is an assessment found in the document, then it is a pointer. It is a pointer towards a assignment of a revenue road. If I gave the grant, namely the property itself is your property, then there is no need to have an assessment, filling the assessment column. If the assessment column is filled up and has been beautifully brought out by His Lordship Vengadadri in 1961, if I remember correctly, if the assessment is filled up, then it shows that it is a land. Then coming to column number 10. This column has had an interesting connotation. In this column, we can find either permanent or hereditary. What is permanent and what is hereditary? If the grant is made permanent, then it is a pointer that it was given to an institution, a religious institution or an almighty. Suppose the second column shows that it is a Devadaya, and the 10th column shows that it is permanent. Keeping two things in mind, we can come to the conclusion that it is a grant made in favor of the Almighty. I said in the opening, the word Devadayam doesn't mean that it is a grant to the Almighty. It is a religious grant or for religious purpose. But if you read that column along with the column number 10, and if the column number 10 shows that it is permanent, it is a pointer toward, because Almighty is permanent. That's the point. If it is permanent, then it is towards the Almighty. If it shows hereditary, and the second column shows that it is a Devadaya, what is the nature? It is a service. The reason is this. Service is intricately connected to the institution, religious institution. And in the second column says that is the Devadaya. And this column, 10th column says that it is hereditary. It will also put the name. If it puts the name, then we will go as a personal grant. If it says or uses the word hereditary, then so long as this person does the service, then hereditarily he is entitled to enjoy the property. If it doesn't show hereditary, and the second column shows that it is personal, then the grant is not in favor of the institution, but in the name of a person, and he is entitled to alienate or transfer the property. This is the interpretation under section column number 10. And now coming to column number 21 and 22. What you will normally find, the remarks is nothing but this entire proceeding is being done by the Inam Commissioner. In every district, he has appointed a deputy collector under a collector from the presidency. And under the deputy collector, some people were working with him to prepare this register. What you would say, somebody comes up with some point, this column number 21 will say that what is the nature of this grant, who is in possession, etc. And lastly, he will use the word to be confirmed. Why? He is not the authority. The deputy collector can only make a recommendation, and this recommendation has to go and be confirmed by the Inam Commissioner. If the deputy collector makes a remarks under column number 21, he will make the last line you can find to be confirmed. And in 22, if any remark is made by the Inam Commissioner, in the last he will say confirmed. If it is confirmed, it means that it has been confirmed by the Inam Commissioner. If the word used is to be confirmed, then it is the recommendation made by the deputy collector and is yet to be approved by the Inam Commissioner. Once these proceedings are over, then the title deed will be issued. We call as the Inam Commission title deed. So Parthiban, can you show the title deed?
Parthiban, can you please share the title deed Mr. Prabakar has sent? Is this on, sir? Can you zoom it, Parthiban? Thank you, Parthi. Kind of you.
That's good. That's it. I can also read that this is a title deed in respect of a particular property in Srirangam. I think it has been extensively argued before Mr. Karthikeyan, the additional district judge. I think he's also there.
Is there? He is seeing your.
I don't want to use this title deed because it is in the press code. But the problem is in some of the other title deeds which I have shared, Mr. Srinivas, it could not be displayed here. Probably you can send it by mail, by WhatsApp. You can share that. But
Yeah, I'll share after the session is over.
Yeah. This title deed, you see, the title deed will be like this. First, you just imagine that this is a type of title deed which will be issued by the Inam Commissioner. But originally it was made in the name of the Secretary of State, who is not entitled to issue the title deed. And subsequently in 1866, there was a special act which says all the title deeds issued by the Secretary of State are deemed to be issued on behalf of the Governor General in Council. That is if you find this title deed, it says by order of the Governor in Council of Madras acting on behalf of the Secretary of State for India in Council, I acknowledge your title to a Devadayam or Pagoda. What is Pagoda? Is a precincts. Devadayam or Pagoda is the precincts of the temple. And then the next wording is important. Consisting of the right to the government revenue on land. If you see, consisting of the right to the government revenue on land, claimed to be 329.91 acres of dry and situated in the village of Srirangam, Palapatrai, Trichy district. And coming down, we can say, we can go up, Mr. Parthipan. This, is confirmed to you and your successor tax-free to be held without interference so long as the conditional grant are duly fulfilled. You can find that this is date of the original grant is 1866 and then subsequently renewed in 1910, 9th April 1910. And if you go down, there is an entry. Can you go up now, Mr. Parthipan? Yeah. There is a value. There is a value which is given as rupees 948. What is that? This has got a rate.
948 hyphen 10
hyphen 0.
0.
This is a value of the assessment because this is a grant of the land revenue. Somebody has made at the time of issuing the title deed the value of the assessment which has to be paid. That is given here, but it doesn't form part of the original grant in the upper portion. But somebody has made an entry. This shows that this is a grant of the revenue and not of the land. There are cases where you can even find a 1.5 page title deed where the title to the property has been given. This is a culmination of what has happened in the Inam inquiry. IFR will be issued and Inam Commission title deed will be issued. Quite sadly, this Inam Commission title deed, a piece of paper, is not available in many of the cases. If it is not available, the IFR is being maintained by the government that is available to the district collector. Therefore, in the absence of a Inam Commission title deed, the courts will be forced to interpret the column from 1 to 22 in the IFR. That's how the problem came. The problem is in the interpretation of all these 22 columns. How it has to be done. Whether it has been properly done in all the cases is really doubt. The title deed issued if it is available. I would like to pose one question. If the Inam Fair Register is available, and if the title deed is also available, and if both of them are not consistent, and one speaks about the land revenue, and the court wants to interpret the IFR as a land itself, how to go about? Sadly, there is no ruling on the point. There is no ruling on the point because it cannot be inconsistent. It was issued only by the person who has done this work, and if you see, the title deed will also be signed by the Inam Commissioner. It will not be signed by the Governor General or the Secretary of State. On behalf of them, the Inam Commissioner would sign. Therefore, if there are 22 entries and the interpretation of 22 entries has been captured in the title deed, and once the title deed speaks about a particular nature of grant, is it open for the court to ignore this document and say that under the IFR, what I am going to interpret, it gives a much larger right to the Inamdar, and therefore I will ignore this title deed and go by my own interpretation. Whether it is possible under law. Now, I will go under the one act. This is the Madras Inam Act 1869. 1866, I will take the three act. The Madras Enfranchised Inam Act 1862, and then the 1866 Act, then 1869. There are three acts in respect of this title deed. what it says. If somebody has read the novel, I'll read the only one section. What it says, I'll read. The title deed issued by the Inam Commissioner or an authenticated extract from the register of the Commissioner or Collector shall be deemed sufficient proof of the enfranchisement of the land previously held on Inam tenure. This is the first step, giving an authentication to the title deed alone. No authentication has been given to the IFR. IFR is only a process. The title deed is the culmination. And then the 66 Act came. What is that? It says, the Act will not have any retrospective effect. And secondly, I read the section 2. The title deed issued by the Inam Commissioner or other officer duly authorized or authenticated extract from the register of the Commissioner or other officer shall be deemed sufficient proof of the enfranchisement of the land previously held on service tenure. And then the third Act came, that is in 1869. What happened was, once this title deed was issued, people start thinking that a better right than what I was having earlier was granted by the Inam Commissioner. Namely, if I got only a right of land revenue, the people on the basis of this title deed claims the title itself to the land. And to clarify the same, there was an act in 1869. And this act would say this: nothing contained in any title deed, therefore, issued to any Inam holder shall be deemed to define, limit, infringe, or destroy the rights of any description of holders or occupiers of the land, from which any Inam is derived or drawn or to affect the interest of any person, other than the Inam holder named in the title deed. Stop there. It shows once the title deed is issued, it will affect the right of the Inamdar. If it curtails the right of the Inamdar, there ends the matter. But it will not curtail the right or extinguish or limit the right of any other person other than the Inamdar. Therefore, a person other than the Inamdar can claim some right over the property, whereas the Inamdar, after the issuance of the title deed, cannot claim any right larger than what has been issued under the title deed. My submission is therefore, once this section or a special act speaks about giving some right, a sufficient proof of enfranchisement, and secondly, curtail the right of the Inamdar that he cannot ask for more, then this act speaks about the title deed issue. It doesn't speak about the Inam Fair Register. But the courts, including the Apex Court, gave so much of importance to the IFR. But we don't find that kind of an importance to the Inam Commission title deed. Why? Many of the cases, if you read those judgments where the court has held that the IFR is so authentic that if any person wants to show that an entry in the Inam Fair Register is not correct, then he must prove the same by coming out with any documentary evidence prior to the preparation of the IFR. That is some of the judgment says like that. In all those cases, when the court was forced to interpret IFR, it doesn't have the intelligence of the title deed. If there is a title deed, and if there is an IFR, and if it doesn't correlate with one another, or it is inconsistent with one another, can the court go against the title deed and give some right on the basis of its interpretation of the IFR? That, to my opinion, cannot be done. The reason is this Act, 1866 and 1868 Act, curtails the right of the court to go into such a question or to make an inquiry independent of the title deed or ignoring the title deed that the title deed is not valid, and I will go by the IFR. That is not possible. But when so many judgments have come on the basis of IFR, as though it is the Bible, and subsequent judges find it convenient to take the IFR alone and to ignore the commission title deed. And some of the judges will say that both of them have to be read together, and I will go and embark upon an inquiry to find out what is in the IFR. That is not possible. That is not the intention of the Inam Commission. And when there is an act which says that is a sufficient proof, if there is an original is filed or an authenticated copy is filed, that is a matter. Why I am saying this? In the Inam Fair Register, there are 22 columns. It is prone to several kinds of interpretation, one in one direction and another in another direction. But in case of a title deed issued, it is a straightforward case of reading what is found there. You don't have to go into the question whether if there is an assessment, it is a revenue, and if the assessment is not there, it is a land. It is a permanent, if it shows as a permanent coupled to the Devadaya, then it is a religious grant to the Almighty, etc. These are the interpretation which one is supposed to make only in the absence of an Inam Commission title deed. My view is that if the Inam Commission title deed is available, then the court has no other go to go by this Inam Commission title deed. Not because it has been issued by the Inam Commission, but because of the act which gives the authenticity to the title deed and not to the IFR. Therefore, the IFR will provide over all other documents except the title deed. And to my view, there can't be any inconsistency between the IFR and the title deed. The reason is very simple. People in those days are more sane. There can't be any mistake. The two, by giving one document speaking about a grant of land, another document speaking about a grant of the revenue alone. That cannot happen because the courts have placed so much faith on the Inam Commission. Given authenticity to the records made by a deputy collector. And then when the Inam Commission gives the title deed, you can't ignore the Inam Commission title deed and higher officer. And then say that this IFR has to provide. IFR will provide over all other documents except the title deed. Now coming to the vesting of buildings. We were talking about the lands, whether it is a Melvaram or a Iruvaram grant, what is the right transfer of sale, etc. What is the vesting of building? Under the Inam Estate Abolition Act, as well as under the Minor Inam Abolition Act, the Act doesn't contemplate the issuance of a patta in respect of a building. The Act speaks about grant of a patta in respect of a land alone. Quite unfortunate. The reason the courts have held that a patta can be granted. The distinction has been made by the legislature. We should have kept the distinction intact. The distinction is this. The Act doesn't contemplate grant of a patta in respect of a Melvaram. Melvaram has to go. In case of a Kudivaram, then he is entitled to, but it has been made so strict that he is not entitled to get. And in respect of a Iruvaram Gan, there is a procedure, I have said about the transfer of sale, etc. But in respect of a vesting section, it doesn't speak about grant of patta at all. It says that a building which is in existence before the appointed date shall vest with the person who owns it. If a person who owns a superstructure in a Inam land, whether it is a estate or a minor Inam, then he is entitled to the superstructure And the explanation would say it includes the site and the appropriate. It is a vesting section. Read the opening is also says it is a vesting of building. I'll take the minor norm and take you to section 13 of the Act. Every building situated within the limits of an Inam land shall, with the effect on and from the appointed day, vest in the person who owned it immediately before that day. But the government shall be entitled for each first year commencing with the first year in which the appointed day falls to levy the appropriate assessment thereon. In this section, building includes the site on which it stands and any adjacent premises occupied as an appurtenance thereto. What it says that if a person owns a superstructure, not a land superstructure in an Inam, he is entitled to the building as well as the site. But quite unfortunately, this section has been interpreted in such a way that a person must own both the superstructure as well as the site to get a patta. Nobody asked for a patta under this section for the building. He is happy. But the courts have held, if you want to get a patta, where is the contemplation of a patta in section 13? No. It says it will vest. If you want to get a patta, you should go outside that to get a patta. But you can't say that you have got the building and the building I am entitled to it, give me a patta, move the settlement on to that. That is not possible. But what happened was, some interpretation made by the High Court, because again, a slant in favor of the religious institution. If the buildings are in existence in an Inam, it says that unless you are the owner of the superstructure as well as the site, you are not entitled to. Then who is entitled to? And some judgments have made a comment, like in AR 1981 Madras, that if a building is in existence on an Inam land, the owner of the superstructure is entitled to the superstructure and the site will rest with the government. What the government is going to do? It says, under the Act itself, I am entitled to every year, but the government shall be entitled to for each year to levy the appropriate assessment thereon. It reserves its right for the assessment. He doesn't want the property. The court said it is not able to reconcile that somebody has walked in, put up a building, and he claims right in respect to the entire property. No, he won't give. You create more problems. A problem, namely, go to the government will be the owner. The Act itself says abolish it. Then what is the meaning of section 13(2)? In this section, building includes the site. Secondly, more saner interpretation. I'm not sure why this has not been argued in any of the courts. In respect of the, if a person is the owner of the site as well as the building, take the example of a minor Inam. If the person is the owner of the building as well as the site, it is not an Inam at all. Why it should find a place? It abolishes the intermediaries. Once the intermediaries are abolished, then it says that in respect of a building, the owner of the building should not be disturbed if he has put up a building before the appointed day. That is 1/4/1960. But the point is that once there is a building, and the court says that you are only the owner of the superstructure, and the site will rest with the government, what the government will do? They don't want the property, but the interpretation made subsequently. To cap it all, there was a judgment in 1996 of the Lordship Sujata Manohar. A very interesting judgment. Firmya Sambandham versus Settlement Officer. 1996 One Law Weekly, page 19. 1996 One Law Weekly, page 19. It was a judgment where the Lordship has come to a conclusion that the concept of a dual estate is not repugnant to the Act. It doesn't say that it is a dual patta. It says that it is a dual estate. What is a dual estate? On facts, and this can be found in AR 1981 Madras because the judgment also reported. 81 Madras page 100, it went to the Supreme Court. On facts, it was a case of one person claiming the site and another person claiming the right over the superstructure. Both of them are not unanimous. There are a batch of cases. In all the cases, the owner of the site, who is not an inamdar, had a dispute with the person who had put up the superstructure, and the person who has put up the superstructure says that I have put up the superstructure before the Act. Therefore, under the Act, I am entitled to the entire property, including the site. But you must remember that what has been abolished is the right of the intermediaries like the inamdar. Religious institution is also called as an inamdar. Inamdar's right alone has been abolished. If two independent persons, one claiming the right over the site and another person claiming a right over the superstructure, as in the case of 1996 Supreme Court, then the concept of dual estate is envisaged. What happened from 1996 to still His Lordship Sirpurkar gave a clarification in 2003. People thought that this also equally applied to Inamdar. 1996 One Law Weekly, if you read the judgment, it would not give the facts. The facts are found in the High Court judgment. In the High Court judgment, it says that it is a fight between two independent persons. Quite unfortunately, what happened once this judgment came, all the lower judiciary found that this is a case of a dual patta issued in favor of the inamdar as well as the person who holds the superstructure. A dual patta. It was never contemplated under law. Assuming for a moment this type of right is given, and if the superstructure is brought down, will the inamdar become the owner of the property? Where there is no superstructure, can such an interpretation be made? It is one thing to say that it is a dual estate between the person who owns the site and another person who owns the superstructure. None of them is an inamdar. And it is yet another thing to say that a dual estate between the inamdar in respect of a site and the owner of a superstructure. The section contemplates about the first thing and not the latter. This has been clarified by His Lordship Sirpurkar in 2003 One Law Weekly, page 663. Vedanarayana Swami Devas Brahmandra is executive officer versus Dharma Devi. In that case, you have to read the judgment once or twice, not enough. Go through the judgment and find what is found. The language used is so strange that you want to give a clarification in respect of a judgment of the Supreme Court. You are then only the High Court judge. Ultimately, he has held that this judgment in Trinyana Sambandham 1996 judgment of the Supreme Court of His Lordship Sujata Manohar is only between two independent persons. It is not a case of an inamdar. To use the language of His Lordship Sirpurkar, he said it is absurd for an inamdar to ask for a site in respect of a building under the Act. Under the Act. Now coming to the presumption that has got a great effect with the interpretation. Under the old law, the presumption is that the grant made by the sovereign is only in respect of land revenue, and if anybody wants to say that it is a grant of both Kudivaram right, including the Kudivaram right, then he has to establish. Then subsequently in 1949, it was the case, there was no presumption. Presumption in one way that it is only a land revenue. And then in 1949, the Privy Council judgment case said that there is no presumption. And subsequently, under the Act, a presumption has been introduced. What is the presumption? Till now, I am not able to convince myself how this presumption can be invoked in respect of all the Inams, especially Inam, which is not a service Inam, one. Two, in respect of a proceeding in a suit. We can find under the Act, a presumption has been given. And for this sample, I will take section 44 of the Minor Inam Abolition Act. Presumption in case of service Inam. Just bear in mind it in respect of a service Inam, not in respect of any other Inam. In proceeding under this Act, relating to any Inam granted for the benefit of any religious, educational or charitable institution, or granted to any individual for rendering service to a religious, educational or charitable institution, or for the purpose of rendering any other service, it shall be presumed, unless the contrary is proved, that the Inam consists not merely of a grant of the Melvaram in the land, but also the Kudivaram therein. You can find, you read it a number of times. There are two things available. In the head note, it says that it is a service Inam. And in the body also, it speaks about the service Inam alone. What happened was, this was confused by the courts, that it is this presumption is available in respect of all the Inams of a religious institution, not alone the service Inam. I'll give you an example. All the service Inam need not be a religious grant. A service can be a Karnam service, a public service, a village helpment, etc. But in case of a religious institution, it can be other Inams, other nature of Inams also as Devalaya. What this section says, if it is a grant in favor of a religious institution and it is a service Inam, then there is a presumption that both the warrants have been granted. There is no warrant for an interpretation that this can be invoked in respect of any other Inam other than the service Inam. Service Inam has got a special place. Why? Service Inam has got an intricate relationship between the service-dar and the Inamdar. And the Act speaks about the abolition of the service. You can find even at the time of Inam Commission, they want to abolish the service, some of the service abolished, and it was enfranchised, as I said earlier. And leftover religious Inams, in case of a service also under the Act. Under the Act, what happened was, the service Inams were abolished. If you see section 21 of the Act, it says that the service-dar can pay money and get it freed from the service. This is one of the cases which is Lordship came, rendered a judgment very recently come.
Yes.
Yeah, service Inam, which it does find a place under section 44. But whether this section 44 can be applied to any other Inam, it cannot be applied. But the thing is, section 44 and the opening words say, in proceedings under this Act, not in respect of a suit, in a proceeding under this Act, that presumption has to be taken. Why? The reason is, under section 20 of the Act, in respect of a religious institution, they have converted all these inams by way of money compensation. Whether it is a Iruvaram grant or a Melvaram grant. If you read section 21 and 22, it says that either in case of a Melvaram or a Iruvaram grant in respect of a religious institution, the religious institution is entitled to domestic allowance. Domestic allowance has to be paid till the inamdar exists or the religious institution exists. Only in such a scenario, these services have been abolished, presumption has been raised under the Act. But in a suit, whether such a presumption can be raised, the direct judgment on the point is, as I said, is the Lordship Madurai judgment of 1949 of the Privy Council in Lex Webinar case. And subsequently, His Lordship, remember Ismail and Pradinichami, the judgment of written by His Lordship K.S. Pradinichami in AIR 1974 Madras, page 182. I think if I remember correctly, in page para number 3 or 4, the opening sentence, he would say, there is no presumption. The grant is a Melvaram or a Iruvaram. That is a division bench judgment, 1974. You can also see there are two other judgments where in a proceeding under the ST, you know, the Act speaks about the proceeding before a settlement officer and then to the tribunal and then special appellate tribunal, STA. Two cases comes to my mind. One is 1998 to 1 law weekly, page 448. And another is AIR 1996 Supreme Court, page 234. In both the cases, about this presumption was raised that in view of the judgment of the Privy Council in 1949, there cannot be any presumption either way. It is for the party to prove. But both these cases, 96 Supreme Court as well as 1998 1 law weekly, are in respect of a proceeding under the Act, namely by way of STA and further to the Supreme Court. Therefore, the court held in the case that is the case in suit, but we are under a proceeding under the Act. Under the Act, there is a presumption. In fact, if I want to borrow the words of His Lordship Goswami in 1998 judgment, he said that was a proceeding before Madurai is a suit, whereas we are in a proceeding under the Act. The presumption has to be applied. Fine. But the problem is, nobody is able to understand or doesn't want to make any distinction between a suit and a proceeding under the Act. Subsequently, we find judges have started indiscriminately using this presumption, even in respect of a suit. I will draw the attention to 2012, 1 law weekly, page 308. Indra Sandraj Arunmega. In that case, if you find the judgment of His Lordship Rajasuriya, not only it is erroneous, but he did not even follow any of the judgments. In two instances, in that case, he had referred to the 1996 Supreme Court on some other point. But in the very same judgment, the Lordship of the Supreme Court said that it is a proceeding under the Act and not a suit. In 74, Division bench said that the presumption does not apply in a suit. His Lordship Rajasuriya went ahead and made a comment that is a too extravagant. The theory is too extravagant. And he also castigated, stating that a suit for recovery of possession is a proceeding under the Act. Quite unfortunate. Quite unfortunate. If anybody wants to say that the proceeding suit for recovery of possession is a proceeding under the Act, it is nothing but absurd. The reason is, the Act speaks about what are the rights of the Inamdar as well as the occupants. The Act says that except the right which has been given under the Act, the Inamdar has no other right, no other right. The right of possession is therefore not available under the Act. If you want to go, it can be only by way of a suit. In 2012 law case, before his Lordship Raja Sudhir, it was a suit. He says that it is a proceeding under the Act. My submission is that it is not correct, erroneous, and not following the settled position of law. These types of decisions, unsettling the issue for some reason or the other, breeds litigation, and it makes the people to come to the court over and over again. The next decision is with regard to the dusting allowance. Why this dusting allowance has got an important place in the Inam Act, and why this has not been seriously considered by the courts. It's quite strange. It is all the Inams are all a grant made by the sovereign. A sovereign has got a right in the, so far as Inams are concerned, by custom he is entitled to resume the property. The Act also says that it is entitled to resume. If it is a service and the service is not done, his Lordship R. Subramaniam has held that it is resumable only by the government and not by the temple or the religious institution. The reason is very simple. The religious institutions are interested only in the service or the performance of it. In so far the right of the property is concerned, it is always only with the government. And if anybody doesn't do the service, the government can resume and make a re-grant. But it doesn't give any power to the religious institution to go after the property. What is the dusty allowance? And one of the judgment has remarked, when somebody has cited this judgment, dusty allowance is a pittance. Therefore, I won't go by it. Forgetting for a moment, dusty allowance is not a complicated process of arriving at the allowance. This Act speaks about an allowance, how it has to be arrived at if it is a male, how it has to be arrived at if it is an irregular. This has been challenged before the Honorable Supreme Court in Kajamian Bhaktestate of the state of Madras, reported in AIR 1971 Supreme Court, page 161. 1971 Supreme Court 161. It's quite strange that including the High Court doesn't want to apply this. This judgment said the dusty allowance given by as a compensation under section 19 and 20 of the Act. 20 is in respect of a religious institution, 19 in respect of others, excluding the grant of pata under section 8. The point is, 20 has got an elaborate procedure for arriving at the allowance. And if this allowance is paid, whether the religious institution is entitled to the property as well as the allowance. It is all, after all, a sovereign granted the Inam, abolished the Inam, and it want to give it by way of money pension. I want to take the money from the government, and I also interested in getting the property from the occupant. That is the theory now. The point is, in Kajamian Bhaktestate case, it was argued before the Supreme Court that this dusty allowance is peanuts. The court said, you have not read the Act. The Act says that it has to be paid annually. It is not a one-time payment. It is forever. It is forever. This is an undertaking. This is an understanding of the Act. The sovereign has to pay the dusty allowance in respect of a religious institution. if the grant is either the Melvaram or a Iruvaram grant, and this money compensation has to be worked out under the Act. The point is, the court said that, if I want to use the word of the Supreme Court, it said that it is for in the beneficial interest of the religious institution. We have all forgotten why the Lordship has used the word that it is for the beneficial interest of the institution, and now the High Courts have said that it is a peanut. The reason is this: suppose the intermediaries are abolished, and if a one-time payment is made to the religious institution, you and I know where the money will go at one stretch. Therefore, the court thought that there is a well thought out legislation granting a money pension to be paid every year, and therefore it is in the interest of the religious institution that the allowance is paid every year. My submission is therefore, this judgment has to be shown in cases where the religious institution is entitled to a money pension and it cannot go after the property. The second judgment on that aspect, rarely we can find judgments on compensation. The executive officer, Sri Raghunath Swami Devasthanam, versus the Commissioner Land Acquisition, 2003-1 law, page 644. His Lordship E. Padmanabhan, in respect of a property from Europe, has held that in both the scenarios, whether it is a Melvaram grant or an Iruvaram grant, under section 21 and 22 of the Act, the religious institution is entitled to compensation that the government has to pay necessarily, can't shirk its responsibility. The point is, if dusty accounts is paid and received by the religious institution, can it still go after the property? If the scheme of the Act is seen, the first part speaks about the grant of patta. The second part speaks about the compensation. And compensation is in respect of a service, there is a procedure. And in respect of other grant, in Iruvaram or a Melvaram grant, there is a procedure. Once you move into the section that the compensation has to be paid, why the religious institutions have been asked to file a suit instead of going for a compensation, which has Lordship Purendi has said. Now we come to the latest decision and why this discussion is necessary. The very recent judgment of His Lordship Mr. Subbaya and Mr. Purendi in Radhakrishnan versus the Commissioner, dated 23/10/2019, and subsequently we are in pandemic, nobody has looked into this judgment. It has taken upon himself to decide upon an issue with regard to a particular in Karur. We don't know from the facts which I could gather, the Lordship would say that it is a service inam. And the service inam that the property were in the hands of several persons, and these inams have been granted by the devotees to the religious institution. I beg to differ. His Lordship is not correct. If it is a religious grant or a inam service inam, it could have only be granted by the sovereign and not by an individual. If an individual dedicates the property, it comes under section 6 of the HRNC Act, namely specific endowment. It may be by way of a gift, or under a will or any other testament it is put in any other document, or it can even be a dedication without a document. But if a sovereign gives, it can only be by way of a inam grant. If it is a service inam granted by the government, then it cannot be by way of an individual giving a service grants. That is the one objection to the judgment. The second is, the Lordships make a distinction between 3 or 4 types of cases. We will stick on to 2. One is, he says, that in cases where the patta has been granted under the settlement clause, that the proceedings under the Act, the temple or the religious institution can go and file a petition under section 78, treating them as a trespasser. 2, if the patta has been granted in favor of an individual abolishing the right of the religious institution, directing the temple to file suits. 3, he says that a suit has to be filed within 3 months and the trial courts have to complete the trial within 1 year. Quite strange. We don't know the calendar of the court. And when I went through the judgment, there are 250 people. We know how the suit will be conducted. It may not be finished within my lifetime. And those who are conducting the suits will be well aware that the direction to file a suit is all right. And he said that the suit has to be filed within 3 months. I don't know whether if such a direction is given and if it is not followed, whether the temples or the religious institution will lose their right. This is only taking the whip and castigating the authorities to file a suit. All right. But the point is, he makes a distinction. Namely, if patta is granted to an individual, file a suit. If patta is granted to the temple or a religious institution, go under 78. Should not discriminate. There are 2 judgments which says there are empty number of judgments. We will cite only 2. 1986 Supreme Court in Ramalingam Swami Madam's case, and 1998 CTC, whereas Lordship D. Raju, sitting in the full bench, held that it is only for fiscal purpose, and in all cases the suit has to be filed. My humble view is that the decision of the division bench is in conflict with the decision of the full bench as well as the Honorable Supreme Court for the reason that Inam has to be treated separately. Probably if it is a case of a dedication under section 6 of the HRMC Act, then it is all right to go into 78. Then also one has to read the Act. Where 78 will come. 78 will come in respect of cases where there is a lease or a mortgage or a license and it has expired and it becomes a trespasser. In all such cases, the party admits the title of the religious institution, comes into possession, squatters the property, then it has got every right to check him out by a shortest procedure which is available under law, namely section 78. But if you want to file a suit and you say that you ignore the settlement clause order and file a suit, probably is it a case of a parent's pet peeve? Courts are the guardians of the religious institution, and who will be the guardian of the common man? None. Therefore, these types of directions which have been given would cause more harm and unrest in the society. In the Lordship themselves have said that the peoples have put up buildings several decades ago, and if they want to give a compensation, go to the commissioner, let him consider and get a compensation. That's all it has been done under the Abolition Act. The Abolition Act is only to put an end to the intermediaries and to make the land freehold so that people can live happily. But now we have come to a stage where the courts have painted these people as grabbers and trespassers. The person who is in possession of a Inam can never be called as a trespasser unless you get a title in civil court. How can you term it as a trespasser when there is an intricate relationship between the Inamdar? Because both the Inamdar and the person in possession doesn't have any title, it is the sovereign. It is the sovereign which is granted. Therefore, the distinction should have been made that the dedication made under section 6 of the HRMC Act with regard to specific endowment is different from Inam. Now conclude by thanking you, Mr. Srinivasa and his college. It was a tremendous effort. It is a having 70, 72 lectures and going on still strong. We will have a treasure trove of some of the good lectures which we are able to hear permanently. By way of, I think it is in the YouTube, etc. I really thank Mr. Srinivasaravan for giving an opportunity for a village lawyer to address an issue which not many people would like to do. Thank you.
Mr. Prabakar, you are not
think
in a you are not in a village lawyer. You are a villa lawyer. See, Mr. Prabakar, I would rather very openly say that when I told Mr. S. Pathasar, the senior advocate Chennai, that you have decided to give a lecture on this topic, he said, "How did you identify the right person?" And I knew that you know the subject well, and I knew you have been handling the case more particularly for the Srirangam temple issue. And I know the subject is well within the heart. But to be frank with you, this kind of deep insight and the way in which you have been referring to all these sections with cross reference to judgments and emboldening yourself in saying that this judgment may not be correct or this judgment needs reconsideration is something which I should say that which is amazing, that reflects the caliber and metal you have. I don't believe in flattery. This session is something I would say one of the very best sessions of our webinar, which I have been holding for the past 73 sessions. So I would say it is one of the cherished moment because the topic is something not very easy or it is not easily understandable. Unless an able teacher teaches Transfer of Property Act, we don't understand the law. Similarly, you deliberated as a skillful teacher and a master of the law, and I would very wholeheartedly thank for the erudition you have shown. So we'll be thankful if you agree once again, if we ask you to go for one more session on a similar law, and more particularly any other subject of which I think you are a master.
With all humility, I'll accept. With all humility, I'll accept, Mr. Rasa.
Thank you, Mr. Prabakar.
One suggestion.
Please, sir.
I think this with regard to after 1950 or 63, there are a lot of judgments that we can go through along with the interactive session.
Exactly, sir. That's what I mean.
Yeah.
And Mr. Parthiban, my friend who is a techie, he is an expert in compiling all judgments and making it a Dropbox. Probably Dropbox is a thing which only youngsters know. For us, it is a box-like thing. A Dropbox is a good idea to condense all the judgments and open as and when.
Probably we have to put all the settlement in their orders and then dustbin.
And one more thing, Mr. Prabakar, I would be happy to say that you have been referring to Ramalinga Saimat case. And the case originated from Madurai Municipal Court, which was handled by Mr. Pathasarath's great-grandfather, Mr. Seshadri Iyengar. And in appeal before Shivaganga Subcourt, it was my grandfather who handled the appeal, Ramanuja Iyengar. When I handled another matter for Ramalinga Saimat case, who wanted to dispose of some trust properties and filing a trust OP before the district court Shivaganga, that came to be dismissed, something different. The appeal is pending before the High Court. When I just went through the documents, I was shocked to see that all these cases emanated from Madurai Municipal and Shivaganga Subcourt. So I'll share the judgment of the original suit from Madurai and the subcourt judgment in Shivaganga Subcourt. And I'm thankful for making me to remember those golden days of Madurai and Shivaganga.
Shivaganga was an estate, right?
Exactly. And there were a lot of scope for estate. Yes, so we had a lot of cases in Shivaganga. Unless and until the tribunals were abolished and subcourt were given the power, we had an estate. Yeah, IIT was there and the Shivaganga Subcourt was the IIT for some time. So once again, I thank you. In my WhatsApp, I have been hearing from Madhavan, from Srinivasaravan's son from Madurai, saying that one of the extensive, excellent session, and Ms. Sheena Pandey saying that one of the most excellent session. the what is called the compliments are pouring in. So I'll share you leisurely. Once again, I could see Mr. Karthikeyan, distinguished Shivanga, he is witnessing the lecture with all the admiration to you. So I thank you once again. For a moment, I'll ask Mr. Karthikeyan to offer his compliments and wishes. Mr. Karthikeyan, sir.
Good evening, Mr. Srinivas Raghavan and Mr. Prabakar, and
Yes, sir.
our witnesses to one of the best lectures that as Srinivas Raghavan was saying. In fact, it is a deja vu for me. I relived a few days actually. One thing I should say is he is consistent. He is consistent. What I heard that day, it has been, I heard him saying today with more precision. So, and I'm also, I also recognize the fact that he has taken up upon himself one of the biggest burdens that he would have ever taken upon himself. And I'm sure you will be seeing him breathing and living only this after some point of time.
So best compliment I think Mr. Prabakar can get. Thank you, sir. Thank you, both of you. Thank you.
Thank you.
May I request Ms. Sheena Paniveli to offer her remarks as a feedback. Ms. Sheena?
Yes, sir. Thank you so much. Sir, I would like to say it was a very informative session. And as a junior advocate, it was an encouragement to read further, to explore this topic more. Because with the historical perspective that you gave, it really, we could completely relate the current scenario with the entire story. So thank you so much, sir. It's an encouragement to read further, really. Thank you.
Thank you, Ms. Sheena, for the kind words. May I request Mr. Parthiban, a lieutenant, to offer his remarks because he is from Shivaganga. Parthiban, please.
Thank you so much, sir. Thank you so much for such a wonderful lecture, sir. It is like half of the time I was like hearing the history lessons from you. Thank you so much. Wonderful lecture.
Thank you. Thank you.
Thank you.
Thank you, Mr. Parthiban. So we'll meet once again in a similar situation on part 2 of this session. I think Inam Abolition Act and the After Effects 2.0.
Thank you very much.
Thank you very much. Thank you. Thanks a lot. Yeah.